Welcome to today's Townsville Flood Webcast. For those of you who don't know me, I'm John Price, Lead Ombudsman of General Insurance. I have with me today Don O'Halloran, one of the Ombudsmen, Evelyn Halls, another Ombudsman, and Michael Brett Young. So thank you for joining up. Just a little bit of housekeeping. Could you please turn off your webcams? We're getting some pictures from some people that really we don't need from this end of the broadcast. We see a lot of disputes at AFCA following natural disasters, in particular floods. Complaints relate to home and contents policies, strata title policies, business policies, landlord insurance policies, travel insurance, motor vehicle insurance. Issues involve scope of works, scope of cover, delays, business interruption, quality of repairs, and often broker advice. The complaints are lodged by individuals, by representatives for individuals, by brokers on behalf of individuals, and against brokers. Today's webcast is designed to assist consumers, industry, and representatives understand the process that AFCA goes through when determining a flood dispute. Don O'Halloran will take you through the slides that we have, and then we'll join with the other Ombudsman, Evelyn, Michael, and myself in answering the specific questions that you may have arising from the presentation. Feel free to post on the chat line various questions you may have, and we'll do our best to answer them. So at that point, I will pass it over to Don.
Thanks, John. Like all disputes that come to AFCA, we start with an examination of the policy and how the policy was arranged. So we look at the terms and conditions of the policy, whether the complainant was clearly informed of the terms and conditions of the policy, and we then move on to what was the proximate cause of the loss. The AFCA approach to proximate cause, which John has talked about on many open forums, provides that where there is coverage for a specific event, but an exclusion for ground movement, and if the exclusion is caused by the specific event, such as storm or flood, then the exclusion will not overcome the specific coverage for the storm, as we interpret exclusions narrowly. But importantly, in all disputes that come to AFCA, we seek to do what is fair to both parties in all the circumstances. Here's a couple of examples of policy coverage. We've got an insured events coverage, which provides specific coverage for storm, and then there's a exclusion for flood, and then the accidental damage policy, which has a similar coverage for accidental damage, but then a specific exclusion for flood. Then recently, within the Insurance Contracts Act regulations, there's been provided with a standard definition of flood. And this standard definition of flood is going to become important during the course of this discussion, particularly because of the use of the words within the standard definition has escaped or been released from the normal confines. There's also, you'll see, our approach to a watercourse, and we regard a watercourse as something that is defined by a channel or something between in the nature of having the nature of banks, and that's important as well, and that will become very important as we go through our consideration of some of these issues. It's also important to note that various policies may include various definitions for what is covered and what is not covered. The insurer carries an obligation to clearly inform the insured in writing that the policy provides cover for loss or damage caused by flood, and the failure of the insurer to provide this clear advice means that the cover reverts to the relevant prescribed contract under Section 35 of the Insurance Contracts Act. Prescribed contracts under Regulation 33 include contracts for home and buildings, home contents, strata titles and loss of damage to equipment and stock, inventory and premises to small businesses. The coverage is, the details are within the regulations include cover for prescribed events, which include coverage for flood under Regulation 19, and a definition of flood, which is contained within Regulation 34, and I'll refer you back to the previous slide. In the course of disputes, it's not unusual for us at AFCA to receive instructions from a complainant that they say they did not receive the PDS, that is, they were not clearly informed of the exclusion for flood. Now, we adopt the approach that where the insurer can satisfy us on the balance of probabilities that it has a robust approach or a robust procedure for the service of a PDS, which likely included the complainant, and there's no evidence to the contrary, such as that the insurer has got the wrong address for the insured, then we would accept that the insurer has, on the balance of probabilities, for the purposes of this complaint, clearly informed the insured of the flood exclusion. Our approach to clearly informed differs depending on whether or not a broker was involved, and differs depending on not we're talking about a small business, and whether the broker was involved depends upon whether the broker was acting as an agent for the insured or an agent for the insurer. Where the insurer's agent fails to clearly inform, then that's a problem for the insurer, and the matter reverts to a prescribed contract. But where the broker is the agent for the insured, not working under a binder, then that may create a problem for the insured and their relationship with the broker, which I'll talk about a little bit further. The definition of small business is important because the definition of small business is different between the AFCA rules and the Insurance Contracts Act. Under the AFCA rules, the definition of small business is a business with less than 100 employees, whereas the Insurance Contracts Act defines small business as a business with no more than 5 employees. And that will become important because under Section 35, which relates to natural persons and small businesses, if the insurer fails to clearly inform the small business in writing that the policy provides cover for loss or damage caused by flood, the policy reverts to the cover provided by the relevant prescribed contract. But that's only in the circumstances, that's in circumstances where there are 5 or less employees. Where there are more than 5 employees, then Section 37 applies where there's been a failure to clearly inform, and it's necessary for the insured to show that the exclusion for flood was an unusual term of a contract, and secondly, that they were not informed of that, clearly informed of that exclusion, and the business must then demonstrate that they suffered prejudice as a result of the insurer failure to advise them of the flood exclusion. So one of the things we do at the start of any dispute is to work out whether a broker was involved in the dispute, and whether or not a broker was the agent for the insurer or the agent for the insured. Where the broker was the agent for the insured, then it's necessary to, if there is a complaint against the broker, it's necessary for the insured to show 3 things. Firstly, that the broker had a duty to the insured or the complainant. That's normally fairly easy because by virtue of the fact that the complainant or insured has engaged the broker means that the broker has a duty to the complainant under the Corporations Act to reach certain standards. Secondly, it's necessary for the insured to show that by not advising the complainant that the policy had an exclusion for flood, the broker breached that duty. And there are some circumstances where it would not be necessary for the broker to do that, but generally you would think that, and certainly in the areas that we're looking at, flood-prone areas in particular, that the broker had a duty, and by failing to advise of the flood exclusion has breached that duty. But importantly, It's necessary also to show that the breach of the duty led to the loss suffered by the complainant. And in a number of areas where we've looked, that hasn't been, the insured has not been able to show that. And that's because of the premiums that would have been charged. The premiums for flood coverage would be prohibitively large. Indeed, in one example in Lismore, John and I spoke to a small business owner where the extra premium would have exceeded the annual turnover for the business, and thus the failure of the broker to advise of the exclusion for flood couldn't be said to have led to the loss, because the insured would never have taken out the policy in the first place, because they would not have paid the premiums. Now, it's necessary to look closely, as I said from the start, at the policy provisions that are applicable to the individual complaint. And there are some policies which provide specific coverage for water escaping from drains. And I'm going to talk about that a little bit further on, but that's a specific provision. And I've given an example on the page there of that sort of policy coverage. That coverage may be subject to an exclusion, but as I've said, we interpret exclusions narrowly. There are two common law rules which we traditionally follow and are supported by the courts, and I think accepted through our consideration of these types of flood claims. The first is that where a property is initially impacted by storm or rainwater and subsequently impacted by flood, and the policy provides coverage for storm or rainwater, including accidental coverage, then the complainant is entitled to the damage that is likely caused by the storm or rainwater. And that applies even though the damage was likely subsequently consumed by floodwater. Of course, the challenge is to work out what was the initial damage, but I'll talk further about that as well shortly. The second common law rule which we follow is that storm or rainwater that mixes with floodwater and then inundates a property is floodwater, even though a part of it is storm or rainwater. We have previously adopted a position that water that cannot enter a watercourse or backs out of a drain to a watercourse because it is full is floodwater. However, as I said earlier, the standard definition of flood contained within the regulations contains the words has escaped or been released from the normal confines of. And arguably, water which cannot enter a drain or watercourse because it is full has not escaped or been released and is not flood. So depending on the circumstances, it may be that even though what water which we previously regarded as flood, it may not be, given this new standard definition of flood contained within the regulations will be applied. And also I'd like to say, and we saw this, John and I saw this specifically in the Lismore area, that many rivers and drainage systems have non-return or overflow valves that lock off when the river is reaching a high. And again, given the standard definition of flood, it is this water that has impacted the property, and it's arguably it's not flood. So eyewitness evidence will be critical at that time. I want to talk to a couple of examples that we've seen recently, and I think a couple of the attendees that are watching today were part of those examples. One occurred in Charlton, and this is to do with whether we should attend on site and have a look at the local area and talk to the local people. I think I've skipped a couple of slides, and I apologise for that. We'll talk about experts and get back to those specific specific examples which I was going to talk about. The experts is traditionally called the hydrologist, and the hydrologist is apparently an expert in the heights and flow of water. To have merit, the hydrologist should be suitably qualified and have attended on site and collected all details necessary to form an opinion, including but not limited to the information provided by the Bureau of Meteorology on weather and rainfall, local weather stations for rainfall amounts, topography details, including the Australian height datum for the local area, eyewitness accounts, photos and videos, river, creek and other course locations. We never accept an expert hydrology report on face value. It's got to be viewed in light of all of the other evidence. One of the attendees today will recall that in Brisbane, we attended on site with a hydrologist who was explaining to the insured why a particular view should be taken. When he pointed to the house, and the insured was able to say, that's not my house is over here. So we just do not accept a hydrologist's his opinion simply on face value. It's got to be looked in light of all of the other evidence, and we don't give much weight to general or regional hydrology reports in comparison to a site-specific report. The first report will be helpful, but it's a site-specific report which we're looking for. On-site inspections are something which I regard as ideal. In the ideal world, I would do them in all of the cases, but I accept that that's not always possible. Now, if there is more than one complaint in the same area, an on-site visit may be achievable. Now, the reason for the site-specific visit is because of the specific topography of the area and the likelihood of obtaining on-site evidence from locals who will be able to explain how events unfolded. And we can see a first-hand location of the property in relation to the immediate surrounding area. Now, getting back to where I was with the Charlton and Lockyer Valleys, I got ahead of myself, but I've caught up again. In Charlton, there's an enormous river called the Avoca River, and it's extremely deep down. And people told us that water came up from that river, exceeded the banks and went through the town, and there was no doubt that that's what happened. However, when John and I and others, including some of our audience today, met with some locals, they took us to a site on the complete other side of town, and they explained to us that water had flowed across a plain which had no defined or anything in the nature of banks, so it was not regarded as a watercourse, going back to the earlier slide and the earlier definition of watercourse. And that water, on the basis of video evidence we had and statements from local people, inundated part of the town prior to the water which came from the opposite direction from the Avoca River. And so in that way we were able to set aside what the hydrologists had said. John and I observed the same thing in the Lockyer Valley when the locals described water coming down from the hills with no defined channel or banks prior to floodwaters from the local rivers. And as I say, in both cases, we were able to conclude that there was some stormwater runoff inundation prior to the floodwater from the river arriving. So the insurer's hydrologist reports did not completely stand up to the local knowledge and eyewitness accounts. When on site and when looking at a file, what we're looking for is a whole lot of information, but generally stormwater runoff occurs at the same time as the peak intensity of the rainfall. Thus, we'll want to know what time was the initial inundation. And that's not always possible because obviously in some of these dangerous events, the people are evacuated prior to inundation occurring, and it's only subsequently that we can try and piece together things and work out an approximation. But on the other hand, we often get CCTV footage and other information, and which helps us to work out when there was initial inundation. And that's, as I say, is important because stormwater runoff generally occurs at the same time as the peak intensity of rainfall. But it's important to remember that rainfall is not always consistent across an area. And what the Bureau of Meteorology does is it goes to its various collection stations. And we've had examples where a collection station will say that the peak intensity of rainfall occurred at this particular time, and there was no rainfall at another time. However, an insured has produced CCTV footage or photographs of a particular time where clearly there's very heavy rain at that time, because there's no doubt that, as I said, rainfall is not consistent across an area. So it's important to piece all of these pieces of evidence together to make a conclusion as to whether there might have been stormwater runoff prior to a river or some other floodwater arriving. And on that note, it's necessary to find out when the river broke its banks. Where did it break its bank? What is the topography in the area? That may impact upon things. And the Australian height datum, which will record the height of the property which is being inundated and the land around, will help. And of course, as I've said a couple of times already, a site visit to get us to put all that together would be most helpful. This slide is one which we regularly see in our hydrology reports, and the green that you're looking at there is the peak intensity of rainfall, and I believe the blue line is the height of the river, and where you get the inner, so then be a matter of working out what time was the property inundated, and if it's close to the peak of the green, then there's the likelihood that there was probably some rainwater runoff. If the time of inundation is nowhere near the peak of the green, then arguably the two are not connected. But again, it's necessary to look at all of the evidence that's available. Stormwater runoff or rainwater runoff traditionally is not going to be as high. John and I have seen floods that have involved many metres of water depth, consuming completely houses, whereas stormwater runoff is likely to be only in the vicinity of 200 to 300 metres. In some cases higher, depending on the topography, but 200 to 300 metres is something which we see on a regular basis. However, having said that, 200 to 300 metres against a wooden door or a plaster wall has a potential to destroy the whole door and would require replacement of the whole wall. You've also got to remember that there's likely to be damage to carpets, wooden flooring, electrical and contents items that may have been left on the floor. It's also important not to forget about damage to roofs, walls, pergolas, sheds and other structures which may have been damaged as a result of heavy rain, wind and hail. And of course they would not be impacted by the exclusion of flood. And indeed, I attended one site in Lismore where the entire claim had been rejected, but you could see water had stained part of the walls because it had come through the roof and was causing damage. And that obviously would not be, again, subject to the exclusion for flood. Now, it is, as I said, complicated where we have a situation where a property has been affected by stormwater runoff and then subsequently impacted by flood. There's unlikely to be quotations or breakdowns or comparisons of the cost to repair the damage for the limited inundation as a result of stormwater runoff compared to the total loss. In those circumstances, we require the insurer to assess the likely damage from inundation up to a fixed height and ask the parties to work together to establish the extent of the loss. And I would say that from a personal point of view, we generally get a great deal of cooperation from the insurers in that regard. Cash settlements, they need to be enough to place the complainant in the position that he or she would have been in but for the event. And the cash settlement must be fair. It must be based upon an actionable current quotation, and it must contain an uplift for the transfer of the risk and the loss of the lifetime guarantee. We consider each case individually because each case involves a different policy of coverage, and each case involves a different on-site topography area. And whilst insureds are often seen to argue that the neighbour down the street was covered, why aren't they covered? There may be reasons for that, but again, it's a matter of looking at all of the evidence available on the particular site. And on the other hand, we consider the complainant's knowledge and experience to be invaluable. And I refer back to the Charlton and Lockyer Valley examples I gave before. They've been through this before and they've done the preparations. They know what's going on and what will likely happen. We're also mindful, and insurers should also be mindful of the personal impact these events have on complainants, and many of whom have lost their houses and businesses, and there are mental health issues which are common. We also take account of the fact that in a catastrophe disaster situation like floods, there will be multiple claims. Now, on the one hand, we accept that insurers' resources will be stretched, including access to builders and assessors. But on the other hand, we are wary of the fact that potential delays will weigh further on already distressed insurers. So that's about it. There's plenty of other information which is available, and we're going to open it up now for questions that you might have that have already been asked. John's going to deal with those and questions you might have from the little chat we've just had.
All right, thanks, Don. Certainly we ask you to get on the chat line and ask some questions wherever you wish. One question that was submitted by Michael Clements from Fairfield Central Medical Practice was, what is the burden of proof to show a broker was negligent in selling a product, specifically if they fail to discuss or disclose exclusion for events such as flood? As Don highlighted there, the onus on a broker has a special duty of care to a person. They enter into a contract with that person to provide services, and they have the duty of care of a person equivalent to a professional person, which they are. What's necessary is to establish that the broker has breached that duty of care, and in establishing a breach of duty of care, you then have to establish that the person has suffered loss as a result of that breach of duty. So it's not just a matter of saying they've failed to explain the exclusions or failed to offer the flood cover. It's also a matter of saying, well, would the consumer take out that flood cover if that had been offered to them, and what was the cost or likely cost of the flood cover? So hopefully that covers off Michael's question. A second question that was asked by Alexandra Kelly at Financial Rights Legal Centre is where the insurance contracts give the insurer a right to elect to repair or pay out. What is AFCA's approach if the consumer wants the opposite to what the insurer wants? Now we hear that a fair bit. We accept that an insurer has a discretion, but as Don indicated earlier, that discretion must be exercised fairly, reasonably and consistent with utmost good faith. If there is a cash settlement that is being offered, it needs to be sufficient to place the person in the position they would have been in but for the loss. And one of the things that we notice with a cash settlement is that a cash settlement transfers the risk to an insured person. So any cash settlement needs to take into account that transferred risk, and a suitable allowance needs to be able to needs to be made for that and for the other contingencies that a person might face. Typically, we will allow an extra 10 to 25% in those circumstances. On the other hand, it may be that we get a scope of works that is unclear or indicates that there are a number of contingencies that it is not costed. In those circumstances, we will often say that it is fair that the insurer complete the repairs rather than cash settle, as it is impossible to know what the likely cash settlement would be. There are examples of that. I've seen cases where insurers have offered to settle on the basis of an inadequate scope of works for $100,000 when we've turned around and said, no, there are too many variables in the scope of works. Complete the repairs, revised scope of works have come in for $400,000. So we're very mindful of that risk that's there. So are there any other questions that have come in as yet? Don't think so.
Not yet.
Not yet? Okay, I'll just continue.
Oh, here's one.
Here's one.
Yeah. So from Bruce Visser.
Yes, from Bruce Visser. What is AFCA's view of applying Wayne tank principles when both flood and rainwater runoff has occurred and flood is clearly excluded? I might throw that open to Don, or to Evelyn, or to Michael.
Well, as I said during the course of the discussion, if for a Wayne tank event to occur, it has to occur at the same time, essentially. And where we have a mixture of flood and rainwater occurring and reaching the place at the same time, then that's clearly flood, because flood that mixes with rainwater becomes flood for the common law purposes of consideration of claims. However, if the stormwater runoff reaches the property first and causes damage to the property first, and then subsequently floodwater overtakes and destroys the property, in particular the earlier part which has been damaged, then the complainant is entitled to the damage likely caused by the stormwater runoff which occurred before the floodwater, and therefore, as a result, in this sort of scenario, there is very little application for the Wayne tank principle.
Thanks, Don. Another question that has been raised is AFCA rules D5.1. When will AFCA decide if a consumer can get some help? How early or late? And that was again Alexander Kelly. Certainly, a consumer can get assistance at any stage they wish. And often in flood-related matters, because of the trauma that people face, they do require assistance at a very early stage in gathering their information and lodging their claim. D5.1 deals with when AFCA will determine that an insurer or a financial firm has to contribute to the costs, and the operational guidelines provide a number of examples where we might award costs. They include complexity, relevance and necessity. It's not just a matter of lodging material, but actually the value add of that information that's being provided. If a consumer were to obtain their own hydrology report and that hydrology report was relevant and relied upon, then it is likely we would determine that the insurer contribute to the costs of that hydrology report. The maximum amount is $5,000 unless exceptional circumstances apply.
Sorry, John, just to add to that, I think also the timing is relevant. So AFCA won't determine that costs will be reimbursed until such time as the complaint has gone through our processes and has been finally determined. So AFCA won't award costs earlier to allow you to bring the dispute. It's only something that happens at the end of the process retrospectively.
Okay, thanks, Evelyn. Another question has come in. Yeah, section 35, this is from, I'm not certain who.
Christina Graff of IHD.
Okay, Christina Graff, thanks Christina. Section 35 of the Insurance Contracts Act. Does cover for flood need to be specified in writing via the schedule of insurance, or does the PDS suffice? Don or Evelyn?
We generally take the view that the provision of the PDS is sufficient. Now, that will depend upon the circumstances, and in the old days when I first started at AFCA 10 years ago, when the 148-page PDS arrived with the reference to the flood exclusion on page 114 in the small bottom corner, I would say that is not clearly informed, but with the smaller PDSs and so forth, we will generally take the view that the provision of the PDS would be sufficient to satisfy section 35.
And I think that also depends, for example, as Don said, on how the PDS has been expressed. So, for example, where you see those clear tables in the first couple of pages identifying what is covered and what isn't, that would be different from seeing just all that cover set out in finer detail later on in the piece. Obviously, to the extent the cover is clearly explained early on and in large and obvious ways, it's easy to understand. That would support the insurer's position, even if it wasn't then on the schedule of insurance.
Also, we've had instances where the certificate of insurance actually is at odds with what's in the PDS. If there's confusion, we often feel that we must, under fairness, deal with it in that manner, which would mean it would probably go in favour of the insured.
So I think what is important to realise is that flood insurance is included in standard cover. So if you wish to exclude or not offer flood insurance, then under the provisions of Section 37B, I think it is, you are required to inform the person that the policy does not cover flood. So insurers who fail to do that, or insurance agents that fail to do that, and in particular Lockyer Valley disputes, there were at least 2 matters where the insurer's agent failed to notify the person that flood was not being offered to them. In those circumstances, the mandatory cover applied, and they were covered under the policy.
Sorry, I think this is just on what we're discussing now.
That also applies for small business. Yes, sorry, from Greenfields. Is that for small business cover? I assume that that's talking about whether it's mandatory or not. As Don explained, if the small business has employees working less than 190 hours per week, so the equivalent of 5 full-time employees, then the mandatory cover applies. So for the mum and dad store where maybe the kids come in of a weekend, the mandatory cover would apply. But if the business is larger than that and has employees working more than 190 hours per week, then it's a question of cover under Section 37, and it doesn't apply in those circumstances. Okay, I think.
This one's also from Greenfields.
Okay, which one's that? If there's evidence, sorry, there's one from Anthony privately. I don't know Anthony privately. Is evidence of water coming from external drains near the property, does that represent storm damage? I'll pass it on to Evelyn or Don or Michael.
Well, it depends on the circumstances again. I mean, is the water coming out of the drain? If the water is coming out of the drain, traditionally it's coming out because the depth of the river, the water course, the lake or whatever, has got so high that it's backflowing and coming out. And under a New Zealand case, which the common law relied upon, that would traditionally be regarded as floodwater. However, with this new mandatory definition or prescribed definition under Section 35 of Regulation 35, arguably it's not water which has escaped because it never got into the water course or the river in the first place, and arguably that is not flood, but rather is stormwater or rainwater runoff.
Yes, you also have policies that specifically provide cover for water escaping from drains. And in those circumstances, if water escaping from drains causes the initial damage to the property, then yes, we would expect the insurer to cover to the extent of the damage caused by that initial inundation.
Just might want to make reference to a Queensland case which followed the Brisbane floods, which a number of consumers got very excited about, which dealt with water escaping from a drains type situation. The reality is that case, which I can give the citing to if necessary, that case turns on the individual policy wording, and if my recollection serves me, the wording was water which escapes from a natural water course, and the evidence was that the drains had been artificially constructed to deal with development in the area, and so that the drains could not be regarded as part of the natural water course and therefore could not be regarded as flood for the purposes of the policy. But as I say, that particular case turned on the particular wording of that policy relevant to the dispute, and so I don't think can be relied upon as a general statement across the board.
Yeah, I guess that does bring into focus again the importance of looking at the specific terms of the policy and also the particular circumstances which occurred, where the water came from, the timing of different events, and potentially, if required, that might involve, as Don mentioned earlier, a site visit from an ombudsman to clarify any of those facts.
Okay, I just, Don did mention site visits earlier on, and I think it is important to understand at the moment we don't have a lot of Townsville flood matters. We in fact have only 3 matters that deal with the question of flood itself. Other matters that we have relate to different issues, but certainly it's our intention, subject to the disputes coming through, that we will conduct site visits, and it is highly likely that those site visits will be conducted by either Don or Michael Brett Young. So that is our intention if it is necessary. We do understand Townsville is a different area, and we do understand that there are a number of discrete areas that have suffered damage, and it has occurred at different times. So it will be important to have a full understanding of that before we make any decisions. One of the other questions asked, again, this is from Financial Rights Legal Centre, was matters of delay. When to complain, at what stage should consumers lodge in AFCA? Are the General Insurance Code of Practice timeframes enough, or is there other relevant information? I think the best advice I can give is that really it is a matter of looking at all of the circumstances of the particular dispute and the particular complainant. I think there are some people that require assistance far earlier than other people do require assistance. We understand insurers have obligations under RG 165 to respond to complainants and complaints. I think that is the first port of call. If you are dissatisfied with the process being adopted by an insurer, lodge the complaint with the insurer. If the resolution through the IDR process does not satisfy you, then certainly you can lodge with AFCA. All right.
So we've got, this is the next one.
Okay. All right. This is a question again from Greenfields, I think.
Oh, no, sorry.
No?
The one at the top.
No,
This one's
sorry.
from Anthony.
It's from Anthony again. I appreciate the transfer of risk with cash settlements. However, what is the expectation of the level of responsibility of the insurer when the customer has requested and accepted the cash settlement over repairs? Evelyn?
I'm sorry, I'm assuming we're talking about where, so a cash settlement's been offered and it has therefore, and has then been accepted by the complainant. What's the insurer's further obligation? So in those circumstances, the insurer's obligation is really around initially making sure that the cash settlement offer is fair and reasonable and is based on relevant information. Once the cash settlement has been made and accepted, the risk then does transfer solely to the insured to arrange the repairs, and the insurer has no further role in that process. So that really emphasises the importance, I guess, of making sure that if an insured is accepting a cash settlement or considering accepting one, they fully understand what it covers and they're satisfied that the amount that has been proposed is reasonable. And again, if there's any doubts about that, it's better to raise those directly with the insurer initially, and if the response isn't satisfactory, then those are certainly the sorts of complaints we look at very frequently.
I think, John, you mentioned earlier that at AFCA we generally think of about a 10 to 20% premium on top because of the fact that the insured is taking on the lifetime guarantee of their own work.
Yeah. Okay. Right. I think this is from Nick Weisner at IAG. I think Nick is. Arguably, water which cannot enter a drain or a watercourse because it is full has not escaped or been released and is not flood. Will this be AFCA's interpretation or not? Industry will require clarity. I think Don has stepped through that question. The definition that is provided under or the standard definition that is provided under the legislation does provide that the water be escape or released from river, dam, etc. So if the water has not or cannot be said to have escaped or been released from a watercourse or dam, etc., then yes, my view would be that that is not flood within the revised definition under the Insurance Contracts Act. Now, we will of course take argument from everybody on those things, and it may be that there is a persuasive argument to suggest that it should be classified as flood, but I must say there was a deliberate intent in the wording that is now part of the legislation, and it would take a very, very strong argument to persuade myself that inundation that did not escape from a river, dam, etc., or was not released from a river, dam, etc., was flood. So I think that answers that question. Let's see. If there's no CCTV or eyewitness footage, how is it possible to prove that stormwater from drains caused damage prior to floodwater entering the premises? I'll throw that open to the
well, first of all, it's a question on the balance of probability, so it's a matter of looking at all of the evidence. We often face situations whereby there is no CCTV, the person was evacuated, it's not possible to detail either the time or precisely what happened. But as I say, it's a matter of looking at all the evidence, and that can involve looking at the topography. And I've been to sites where the driveway up to a house is, may involve a climb of a metre over a 20-metre length, which means that the house is sitting up high. The house may be raised on bricks, whereby there's steps up to the house, and it's fairly easy. This is the obvious example. It's fairly easy in those circumstances to accept that it's unlikely that stormwater runoff could occur in that situation. On the other hand, I've been to houses that sit in a gully or a lower part, and there's a hill next door, and there's evidence that water does flow down that hill and towards the direction of a house, and it's not hard in those circumstances, that even though no one was there at the time, to accept that there was a possibility of stormwater runoff. And then of course we go back on to talk about when was the peak rainfall occur, when did you leave the house, when did you return to the house, when did the river flood, so that we know the banks, the water's coming over the banks. Putting all that together, it is possible to reach a conclusion on the balance of probability. It was likely that stormwater did reach the house prior to floodwater reaching the house. And as I say, there are examples where it's most unlikely, and it's not possible to say that stormwater would have done so.
Okay, another question that's been raised from Sarah McPherson, I think.
Oh, that's right.
That's here. What's going on? Sorry, how does AFCA deal with partial rejection of claims on the grounds of maintenance issues? i.e., what level of detail is the insurer required to provide to the insured? I'll pass this over again to the others, maybe Evelyn.
Yep, sure. And I assume here again we're talking about where an insurer accepts part of the claim that's made on the basis the damage was caused by stormwater or flood, a covered factor, but other damage was caused by maintenance and therefore won't be covered. I suppose the first point to make is that where the insurer seeks to exclude damage, they bear the onus of showing that the damage is excluded if the insured has established a prima facie claim for a covered event. So we will be looking to the insurer to show clear and specific evidence as to why the damage that they are excluding was caused by maintenance or by other excluded factors. Again, we would expect to see reports, photographs, those sorts of things, which make it evident to us that this clearly was damage that was pre-existing and caused by other factors. Equally, if there's countervailing evidence that the insured can provide, for example, photographs of relevant parts of the property prior to the weather event, that can be very useful, or any reports from their own contractors or from previous tradespeople who've worked on the property, anything of that nature which establishes its state prior is going to be very helpful in rebutting that argument that might be put forward by an insurer.
Okay. I think this is the final question that's come up there, but certainly but feel free to lodge further questions on the chat line. This again from Nick. There are likely to be pricing implications as a result of broadening the definition. Has this been considered by AFCA, particularly considering existing affordability issues in North Queensland? Simple answer is that it's not a question for AFCA to determine the issues around pricing implications of a legislative change, but we have certainly made submissions to the various inquiries into the affordability of insurance in North Queensland, the most recent inquiry being through the ACCC. So we're certainly aware of the issues with pricing, and we're also aware of the importance of mitigation in these areas and have made submissions with respect to that. But in terms of this change to the legislation and the definition, that is something that the industry will need to factor into how it deals with these type of disputes. Okay, I think we've basically done all of the questions. One of the things that we haven't really ticked off is scope of works, and we do get lots of issues about those. So it is important that we have detailed scope of works provided to us. And I think hopefully from the flavour of this discussion, what's occurred is that you understand the importance to us of recognising and determining whether there is any initial damage to a property, and if so, the extent of that damage. So it is most important for us to determine whether whether there was damage before water escaped or was released from a dam or a river, etc. So it's very, very important. Provide us all of the documentation. Tell us if it's for a consumer. Tell us the history. Tell us the story. If there is video information or evidence, provide that video information. If there are eyewitnesses, provide the eyewitnesses. Neighbours are often very, very handy in providing information. So first-hand accounts are most important, because first-hand accounts will often be preferred to those of hydrologist opinions, in particular where the hydrologist report is not a site-specific report and the hydrologist hasn't taken the opportunity of speaking with the particular complainant. So if there are no further questions, and I don't believe there are, we will arrange to email you